So I'm sorry to interrupt the conversation. Please enjoy your meals, but I do want to give the microphone to our friend Professor Epstein as quickly as possible. So let me just say a few brief words of introduction. And before that, though, let me introduce a little bit of the work of the C. Boyd and Gray Center. The center was founded 3 years ago, as Dean Butler indicated, by Dean Butler and Professor Naomi Rao. The idea being that with everything happening in administrative law, new debates being reopened in Congress, in the courts, and in the executive branch, now was the ideal time to create a program, a home, for these sorts of discussions and debates. And it's my pleasure to inherit this program from Professor Rao upon her move to the White House. So we do a few things. First and foremost, we do the sort of thing you're seeing today. We invite scholars to write about a particular topic and then debate it amongst themselves and then publish their papers. Now, this symposium is different from all of our other events because normally we don't publish all of the papers in one given place. We have a private workshop and then a public conference, and then we let 1,000 flowers bloom and let the authors take their papers wherever they would like. We do like this new format for the annual symposium, working with the Law Review, but we also love the fact that our scholarship is published in all manner of journals. So we just had to cancel 2 weeks ago our latest conference due to the storm threat complicating travel. Can you hear me? I just went off. Okay. Can you hear me now? Okay, great. I know they want to hear you. I know you don't want to hear me. But just very briefly, we had to cancel our public conference on religion and the administrative state. That'll be rescheduled for the spring. Tomorrow and Friday, we're having a 2-day conference we call New Normals, ? Emerging Issues in Administrative Law during the Trump administration, where we have a number of scholars, including some who are also presenting today, who are writing on different issues arising in the new litigation surrounding the Trump administration's agencies. So everything from Chicago's Jennifer New on the civil service bureaucracy to South Texas's Josh Blackman on what he calls the canon of presidential avoidance, and then a paper by Ron Cass on nationwide injunctions and many more. So we'll have that private workshop on Thursday, Friday, and a public conference in December. In October, we'll have a private workshop on papers surrounding the delegation issue and a public conference in the spring. In addition to these cycles of workshops and conferences, this year the Gray Center is inaugurating a series of one-off sort of standalone events, seminars. We'll probably have most of them in Washington, D.C., beginning with some events at the Decatur House near the White House, where we'll just pick a topic and have a panel discussion and then cocktails. Hopefully cocktails before and after, for the sake of conversation. But for example, on October 17th, we're going to have 2 events in one day. We'll begin with a half-day conference on the issues at the Veterans Administration, both the procedural side of things and judicial review. That'll take up the first part of the day. In the evening, at the same location, we're going to have a speaker on what we call the architecture of bureaucracy. And we don't mean that sort of metaphorically. We're actually having a scholar of classical architecture come and talk about the evolution of government architecture in Washington, D.C., and what we can glean from the sort of intellectual underpinnings of that shift. On October 10th, we're going up to New York for an event with the Manhattan Institute, where the Treasury Department's General Counsel, Brent McIntosh, I think one of Professor Epstein's students maybe, Brent McIntosh, is going to be, well, you've had a few. He will be speaking on the prospects for further regulatory reform on financial regulation. One last thing, as I mentioned at the outset of this event, it's a real pleasure to get to work with the students on the Law Review. As it happens, this year the center is actually expanding its work with students. We're inaugurating a program we call the Alexander Hamilton Fellows, not just because we wanted to name it after a Broadway star, but we thought who better in our American history has reflected on both the rule of law and the practicalities of public administration. And so for students in the room, if you're interested in this, just consult any of the elevator flyers while the application process is still open. We really would love to welcome some students into our work to do some of their own research, to aid our scholars with their research, and to help out at the event as so many students have helped today. All right. Well, that said, without any further ado, it's my great honor and pleasure to introduce our keynote speaker, Professor Richard Epstein. He's the Lawrence A. Tisch Professor of Law at New York University, the James Parker Hall Distinguished Service Professor Emeritus and Senior Lecturer at the University of Chicago. And he's also the Peter Kirsten Senior Fellow at Stanford's Hoover Institution, which I will get back to in just a moment. Now, Professor Epstein is one of the most significant legal scholars of our time. In the many books and articles that have influenced generations of judges and lawyers, and also the many students who themselves have gone on to become judges and policymakers, including the ones that Professor Epstein doesn't remember because he's had so many of them, but also including our center's founder, Professor Naomi Rao. Now, he's been a member of the American Academy of Arts and Sciences, and in 2011, he was awarded the Bradley Prize. Now, I mentioned that Professor Epstein is also a fellow at the Hoover Institution. As it happens, I work there some of the time as well. And one of the great perks of that job is I get to record a podcast every few weeks with Professor Epstein. We call the podcast Reasonable Disagreements. I think it's because each week I try to be very reasonable and Professor Epstein disagrees with me. But jokes aside, those conversations bring me great joy, as does this opportunity to welcome here to the C. Boyden Gray Center. So please join me in welcoming Professor Epstein.
Adam has the following maxim when we have our debate: better to be reasonable than right. And my position is often the opposite: better to be unreasonable and right in the way in which you start to deal with these kinds of issues. There's actually something about this which relates to this talk, which is based loosely, very loosely, I might add, on the paper that I wrote for this volume, which is the extent to which, when you're dealing with topics like separation of powers and due process, what you tend to do is to gravitate, can you hear me all? Whether you tend to gravitate towards per se rules of one kind or another, or whether or not you tend to move back in the direction of balancing. It would be an extraordinarily easy world to live in if it turned out that one approach was always better than the other, but it's a much more difficult world to live in when you're never quite sure whether or not the balancing approach is the correct way to deal with kinds of issues, or whether or not you ought to move more sharply in the direction of per se rules. And the various topics that we have here, I think, indicate just how difficult it is. Now, the basic structure of the paper that I wrote, which went on much too long, but you're not going to shorten it, was to try and figure out the way in which we deal with three particular institutions that are designed to ensure the probity of various kinds of decisions. And the three rules that I'm talking about in this particular case are not substantive rules, like a rule protecting against takings and impairment of contracts and so forth. They are all things which would be either regarded as structural or as procedural rules. And so there is always a sort of an initial question as to whether or not these particular rules could ever have the function of securing substantive rights once those are properly defined. The three kinds of rules that are involved in this particular situation are separation of powers rules, and separation of powers could either be a very rigid concept or a very muddy concept, and one has to figure out which way it ought to go. In fact, it goes both ways. The second has to do with the Appointments Clause, an issue which was actually involved in explicitly in the Lucia case, but was implicitly involved in the oil states case. And it turns out Gary Lawson, who is one of our most tenacious scholars of administrative law, has written a paper coming out in the George Mason Law Review saying, in effect, that the oil states guys are, in fact, principal officers who need Senate confirmation because they are so much like federal judges that they have to be treated in exactly that way. In other words, if you live by the sword, you have to die by the sword, and this is a case in which that is true. And then the third particular feature of this particular triad is, in fact, the question of what kinds of procedural due process protections are going to be given in these various contexts. And it's quite clear that that issue, of course, was latent in both the Lucia case on the one hand and the oil states case on the other, but was not explicitly adjudicated and litigated in either. Now, essentially, the reason why one starts to think about these three things in tandem is because the two major cases that we had, oil states and Lucia, raised both of these issues. I might add that just yesterday I was on a panel with Judge Andrew Efron and my colleague Troy McKenzie talking about a case which has not been mentioned here, which raises many of these same issues again, which is, Aditya, where are you, Mr. Bamzai? The Ortiz case and the question, he's still smarting from his defeat, but I don't want to argue the merits, but it's exactly the same kind of problem about the extent to which you have separation of powers issues, which deal with the origins and the movements of the military courts of one kind or another. And I got interested in that because I actually taught military law last year for the first time. And you would ask, why would I do it? The same thing about Mount Everest. It's there, so you might as well try and understand something about it. And it became clear to me it was a much more important sort of issue. So why is it that these three cases, and particularly the last two, oil states and Lucia, raise such a difficult question? It's because if you actually go down and start looking at the facts of these particular cases, what you are is absolutely appalled about the way in which these things are handled under the most elementary conceptions of fairness in individual cases. You have courts which essentially are jerry-picked for the particular occasion. It turns out that Mr. Rushke, who's mercifully been fired from his basic position as the head of the PTAB, sort of announced that I stack the panels with people whom I want. I consort with people who are going to come before me. I reserve the right to put myself on a particular case to change the outcome in the middle of a situation. It is utterly intolerable that you do anything with respect to adjudication which does not follow the problem or the practice of anonymous rotation of judges. There's a nice article by a woman named Maren Levy, I think in the Cornell Law Review, which goes very clearly to the extent to which all of the federal circuits go to preserve this principle as a general safeguard against bias. And the thing to understand about it, it's a prophylactic rule. It's not that you can prove or ever going to want to prove in an individual case that a judge who's handpicked for a particular situation is subject to bias. But the old rule with respect to bias was always one that dealt with an appearance of irregularity as well as a fact of irregularity. And so the central position was you want to make sure that the appearances are correct so you don't have to get into grubby factual determinations as to whether or not the bias did or did not exist in a particular case. When it comes to Mr. Cameron Elliott, it turns out this man is 52 for 52. Every time he'd been asked to review a provision inside the SEC, he announced in advance that if you fight me, I'm going to really throw the book at you. And sure enough, in this particular case, on a series of wholly frivolous facts, he suspended somebody from his entire professional career and fined him several $100,000. And of course, this was set aside by virtue of the fact that it did not satisfy all of the appropriate requisites for an inferior officer under the Appointments Clause, but treated him as a mere employee. And once you start to see things like that, the next question you start to worry is, what can you do about this? And the first thing to understand about all of this is that this may seem to be, as I said, only structural or procedural issues, but it's important that you understand that there's a very close connection between these things and substantive questions on takings and so forth. And the way in which I like to point this out is to ask about the relationship between procedural and substantive due process. And on the procedural side, when we start to talk about things, we're talking about bias. And with substantive due process, what we're talking about is the kind of protection of certain kinds of property rights like liberty of contract and so forth, and takings. And if you go back historically, the connection was really understood in connection with the rate cases, where Justice Harlan in a single sentence said, oh, I see this provision which says, nor shall property be taken without due process of law. And everybody knows that that last clause means without just compensation. And from that, we managed to get this huge apparatus dealing with rate regulation in the late 19th and early 20th century. And the way the connection works quite explicitly is this. Think of procedural due process as a situation when there's a 50% chance that the plaintiff will win. He wins 50% of the time. And if you want to figure out how to skew things, what you do is instead of having a fair dice, what you do is you just simply change the 3 so it's now an even number. And now it turns out that whenever you roll these devices, it's going to be 4-2 instead of 3-3. And the way you have to think about that is they're basically taking 1/6 of the property rights and giving it to the other guy by virtue of having a skewed procedure. So every time you simply have a skewed procedure, what you do is change the expected value of an outcome in a case, and that is an implicit wealth transfer from one party to another. And so therefore you must guard against these kinds of mistakes, because if you do not do so, then you're going to see transformations like that take place all the time. And the reason why the procedural due process notion is so powerful is it works orthogonally to what your substantive definition of rights is. Whatever the rights are, you can take as given for these particular purposes and then assume that the skewed panel will necessarily deviate from whatever it is that the substantive rights ought to be. And that has to be regarded as a very serious deviation. The use of procedures to undermine substance is a fallible conception that exists regardless of what the substantive norms turn out to be. Well, when you start looking at these cases, then how do you want to think about these three devices? And the way in which I say it is that you have to ask the question to which the extent that they serve as prophylactic rules. And what is a prophylactic rule and why does it matter? Prophylactic rule is one which essentially is used to prevent certain kinds of abuses from taking place, and it is done with a conscious design that it's going to be overbroad in the way in which thing is going to be implemented. And the moment you say that a rule is going to be overbroad, the appropriate response that you're going to have to deal with is as follows. Overbroad rules essentially are excessively protected, and there are going to be some cases where they're going to invite one kind of error, to with the kind of error of keeping a panel from deciding a case that it ought to be able to decide. Well, how do you decide whether or not that cost is worth bearing is an empirical question, but on the other side, the question is this. If you don't have the prophylactic rule, what is the likelihood that a system of case-by-case adjudication is going to be able to identify the errors that arise in the opposite direction, namely those in which the ad hoc biases that you observe are in fact going to result in an unacceptable shift of the substantive rights? And the empirical claim that is made by the founders, and it's one that I tend to accept, is that this is likely to happen at a very, very often way, and so therefore some kind of protection has to be given. What kind of protection is very interesting? What happens is, go back and read, I think it's Madison in the Federalist Papers number 47, where he announces that he's strongly in favor of the, it's a Madison, how doesn't matter, Madison it is strongly in favor of the separation of powers as a protection and a bulwark for individual liberties, because it's intolerable that all the kinds of biases and connections should undermine the system of substantive rights. The Lord giveth, however, and in the next sentence he takes it away. And what does he do in that next sentence? He announces very clearly, this only applies to situations where you have simply, when you insist in these particular cases that you have to have some separation. But he's willing to say separation doesn't have to be total, and that we'll have partial separation. And at this particular point, there is now a real tension, as everybody understands, between the system of separation of powers, which says I'm autonomous in soul, and the system of checks and balances, which says exactly the opposite thing. And the reason why it is that it's so difficult to organize a set of constitutional doctrines on this particular point is you never know at any given moment whether the appropriate system of prophylactic rules is one that calls for checks and balances, at which point you have the interpenetration between two branches, or whether it calls for separation of powers, at which point the one is autonomous vis-a-vis the other. And I think with respect to the issue of separation of powers, that the appropriate answer under these circumstances is it depends where you are in the cycle. So I think the checks and balances principle is extremely important in the way in which you appoint people to various kinds of positions, and the whole theory associated with presidential nomination and senatorial consent on a plenary basis, that is, they could accept a decline without having to give reasons, is that it is too much of a power to give the president the ability to appoint key issues or key officials. You want to have somebody else look at the way in which these people do, for fear that he will skew the deck in his particular favor. And the Senate is therefore an appropriate check. But it doesn't follow from the fact that you want to have that kind of check at the appointment process, A, that you want to have it at the removal stage, where I think the answer, certainly with respect to key federal officials, is exactly the opposite. You can't expect the president to work with an attorney general he does not like, and that's the situation you have currently with Mr. Sessions, and you can see just how difficult it turns out to be when you have this loveless relationship going on in very, very high places. So what happens is you could fire at will, but you can't hire at will. And one of the constraints against firing at will is you got to hire somebody else, and that's going to put you back into the senatorial situation. Not a perfect situation, but a sensible one. On the other hand, when it starts to coming about the way in which you want to decide cases, the last thing you want to do is to have some kind of administrative oversight by the president or somebody else. So if I were to suggest, for example, that any decision made by Judge Douglas Ginsburg should be subject to reversal and review by a presidential veto, and if he doesn't like what's going on, that decision is uprooted, that is also a form of, shall we say, checks and balances, but not even with you. But with anybody, we don't want that particular kind of system because it utterly compromises the way things start to work. So we come up with this very elaborate set of rules, and in the end, it seems to me that Justice Kennedy was right when he said that the separation of powers is an indispensable protection for individual liberties because the abuses that are likely to happen when it is not done in the adjudication of particular cases is there. So what we mean by independence of justice is that they can't be meddled with when they start to make decisions. It does not follow, in my view, that independence of justice requires lifetime appointments subject to dismissal only for bad behavior. It seems to me, as many people hinted today, that under God's vision, if you had to put together a new Article 3 today, you would not have lifetime terms. You would have 15 or 18-year terms, which is what we have under Article 1, and some of the comments that were made, right, Mr. Rappaport and so forth, is all things considered. An Article 1 organization with 15-year terms and some degree of independence is better than the current system that we have, which gives terms that are much too long and allows the world to be controlled by people as old as me and Boyd and Gray, or even older, which is, I think, a mistake in terms of the way in which you want to run government powers. So when it comes to cases like oil states, it seems to me that the position is completely misunderstood by Justice Thomas. It's, in my view, one of the worst opinions ever penned because it simply screws up every particular case that's involved and misses the fundamental principle that dominated 19th century law. And that particular principle is quite simply an administrative agency, before it makes a final determination, can decide whatever processes of internal review it wants to have or not have. But once it decides to throw this thing out as a final judgment, then there's the creation of a property right. That was, by the way, the definition of a public franchise was a property right. And at that particular form, as a property right, the only way in which you could deprive somebody of it was through an Article 3 court, giving you all of the substantive and procedural protections that come with any other form of property right. That's a very clean rule. It was, in fact, the 19th century rule. And one of the saddest lines in the history of American Supreme Court jurisprudence was Justice Thomas's complaint that, if they had only seen the inter partes review process that we've just put into place, they surely would have changed their mind about the entire issue. It just is plain false. They got it right. It was stable. Indeed, it applied to all kinds of patents. So then what is it that we can do inside the administrative thing under Article 1 is a fair question. I talk about it at great length in 3 articles that I wrote on oil states, which are published in the Federalist Review. Adam is going to deal with it, I think, much more thoroughly than I would. But I think the basic point that one wants to say about this is that when you are talking about public rights, the original definitions all had to do with the following situation. You had disputes between a grantor and a grantee in a property case, where the government was the grantor, or you had a dispute between a tax collector for the government and the government as to the monies owed. Originally what happened is that you would try to get disputes over these disputes, and there'd be an informal adjudication process inside the agency, and then slowly that morphed into a court. So by the time you had the Murray's Lessee case coming down in 1855, what had happened is these courts had been in place for 35 years at the federal level, and had been in place at the founding very much long time before that. And so what the Supreme Court said is, I just don't want to upset this particular situation. So that public rights essentially meant disputes over grants. It did not mean disputes over statutes. So it would be a clear mistake, given Murray's Lessee, to say that every time the government decides to make a grant by way of a statutory provision for the creation of patents or trademarks or so forth, The mere statutory intervention can always undercut Article 3 courts by appending to it the following language: the property rights that we create under this case are hereby to be adjudicated only outside of an Article 3 court with no protections whatsoever. Take the bitter with the sweet. A system of separation of powers does not allow the Congress, by its own legislation, with or without the approval of the president, to do in the judiciary with respect to its appointed function. Now, the second area that one has to deal with is the question of the Appointments Clause. And this is, I think, an extremely difficult kind of subject to deal with. But let me give you my basic position on it, which is I don't think in the end this is an important protection of individual liberties, notwithstanding the great weight that the Chief Justice has given to it in his variety of cases. And let me mention to you a couple of the difficulties that I think support this. First of all, take something like the PCOAB case, in which the question is whether or not the president can be 2 levels removed from dismissal, such that you are having these various peoples doing the accounting board who are dismissible by the SEC, but not by the president. The whole point of basically giving these guys 4-clause protection is not to protect them from the president. The president can't do anything about them anyhow, because he's never going to be able to get through the SEC commission. The real question of administrative law there is whether you want this professional panel to be insulated from a very political SEC. And I think the answer to that case is, all things considered, I would rather have protection against the SEC so this is an independent agency that you can't touch. And so I would want to support this particular situation. Since the president has no role anyhow, given the fact that it can only get rid of the SEC commissions under such narrow conditions that they never apply, this is a question not of constraining the presidential power. This is the question of how you constrain an independent agency which has a tendency to go off the rails much too often. And I think you have to be extremely careful about this. And so I would have reversed that decision, given the fact that we've decided to put these administrative agencies on an independent status with Humphrey's executive. At that point, you're trying to work in a second-best constitutional law, and this was a better result than the alternative. The second situation that you have here runs as follows. It goes back to the special prosecutor case, Morrison against Olson, and I thought that a decision by Justice Rehnquist is up there as one of the worst decisions ever in the history of the United States Supreme Court. As you note, there are a number of very powerful contenders for this particular title, and we have to decide which of them we're going to survive. But what does it mean to say that you will now allow inter-branch appointments where members of the federal judiciary, and we don't know which ones, will appoint a special prosecutor over whom they have no oversight responsibility and for whom they bear no political accountability? It seems to me to be just a terrible mistake to do this stuff. There is no reason whatsoever to get the judiciary involved in this kind of thing. And then to ask the question is, now that you have this unguided missile going through, the only oversight is going to be by the Attorney General under terms that are so circumscribed that it's a virtual certainty that unless she commits mayhem, that is the special prosecutor, she's going to be there. And sure enough, you saw exactly the kind of abuse that you're always to be afraid about. Somebody with no institutional constraints and an unlimited budget can hound somebody half to death. And the point of the Scalia dissent, this is a wolf in wolf's clothing, was essentially to point out the kind of abuse. So in the cases where you really want to have some appointment powers protection, the United States Supreme Court has basically abandoned it. I would recommend that they put this back into place. I don't care much about interbranch appointments between the president and the legislature. I do think that if you want to keep the separation of the judiciary there, you do not want them getting meddled in any way, shape, or form in any kind of political activity. And again, I'm not saying this should be a fact and circumstance determination, which is the way in which Justice Rehnquist thought about it. When it gets too bad, I'll do something about it. It should be an absolute per se rule. This is not a case in which there's any reason to do this. If you want to have political parties accountable, by all means, make them accountable for what it is that they have to do. The third situation, however, is situations like Lucia and other cases. And here, all that you can say is that if you follow the opinion of Justice Kagan, which I thought was right on the particular facts, if you don't have final authority, it doesn't mean that you're not an officer of the United States in some sense, but a mere employee. But what happens is it's too easy to fix this up. And what do I mean by that? Is, well, they've already changed the procedures inside Lucia. The Trump administration, to its great credit, refused to defend the processes, and they hired some independent lawyer to defend this thing. And now what they do is they simply say, okay, what we're going to do is find the appropriate head of office, whether it's the chairman of the SEC or the head of the Department of Commerce. It really doesn't matter. Give a stack of 15 appointments on a piece of paper and have them sign one after another. It's a rubber stamp piece of protection. And in an odd sense, the problem becomes even worse after Lucia than it was before, because now there's a safe harbor through which you can run exactly the same kinds of people with exactly the same kinds of consequences by just changing the signature on the piece of paper. That is not, in my view, a long-term form of constitutional protection, and it's not one that we should, in fact, endorse or suspect. I'm not saying you don't want to do it, but don't be under any illusion that you fixed anything in a fairly serious way. So this then gets us back to the question about a procedural due process, which was left out of all of these cases. And here again, I think the way in which this thing seems to be teeing up is that we are thinking that we are in Matthews and Eldridge land, and that what we do is we look at these cases, figure out the stake of the government interest, the stake of the private interest, the various kinds of alternatives, and so forth. I think that that approach actually has some sense in those circumstances where when the government does is decide to give welfare benefits of one kind or another out to individuals. There is a claim that was rejected in Tam v. Mattel, and rightly so, that somehow or other giving a patent and giving a welfare benefit are exactly the same thing. The difficulty, of course, is that you have to actually earn a patent by explaining why it is that your invention is merited protection, and the same thing with respect to with respect to trademarks. One of the really striking features about the whole oil states opinion is that nobody seemed to think that anything that was said in the Tam case had anything to do with the oil states case, when in fact they're exactly the same problem. What you do is you have a series of property rights which are inchoate until the state comes along, and then you protect them. What Justice Alito said in Tam is you cannot treat the fact that the government strengthens a series of private rights as though somehow or other they become a government subsidy. And now when it comes to oil states, all of a sudden you're starting to think that this is Goldberg v. Kelly or Matthews and Eldridge. It's a mistake. So then what do you do? Once you've decided that these grants are in fact completed transfers of property, which was the correct 19th review on the subject, rejected, then in effect, when you're talking about removing them, you're talking about the need for a standard kind of case. And the only rule that works in these circumstances is a per se rule, which says that you cannot have a situation in which the appointment could be made with knowledge of the people whom you're appointing in an effort to skew the results in one way or another. This is not a situation where you want to say, well, we're going to weigh the expertise of the patent office in one hand as against the strength of the claim on the other side, and in some cases we'll do it this way, and in some cases we will do it that way. This is not an area in which case-by-case adjudication has a chance in hell of getting things right. And what you have to do is to sort of lay down a clear rule. It's a prophylactic rule, but the cost of putting it into place are virtually nil relative to the kinds of abuse that it's going to deal with. And so I think what's going to happen, and Megan mentioned this in her speech today, is that you're going to see a transformation of what's taking place inside the PTO. And the question is, well, why are they doing it? I think, in effect, that they recognize, as the head of the PTO recognize, that the procedure is so rife with abuse that what you have to do is to convert this thing so it looks more like a standard kind of trial. And the way in which you can do this is to understand the following claim. Whenever anybody says about an administrative agency, we want to give them discretion because they have a degree of expertise, the appropriate response is to look with deep suspicion on that claim the moment it comes to the question of how it is we read and interpret statutes. Many of these statutes are used in cases where there are no administrative agencies involved whatsoever. Judges do better or worse under de novo review. My view about it is that the same rules for interpreting statutes that go through an administrative agency should be that which is given to statutes which do not involve any administrative agency. If the agency actually has something to say on the merits, let it say it. And if it turns out it's right, it wins. If it turns out it loses, it's wrong. But they don't get any special purchase over even a student law review note. That's how far I'm willing to go when it comes to the question of appropriate kinds of deference. Nobody has ever thought that in cases that involve no administrative agencies, you give deference to anybody in any particular way. There's no reason to change that rule when an administrative agency is involved. Some of these statutes will, in fact, have both direct reviews and administrative reviews, why you would want to cloud the situation is beyond me. So essentially what happens is I regard procedural due process as the second tier of defense. If you've lost on separation of powers, as one seems to have had, it is the case in oil states, what you then have to do is to take the same kind of concern for the fairness of process and use it to erect a strong due process rule per se. The difference between this is instead of having the thing done in an Article 3 court, which for patent disputes I think is always superior, now in effect what you're trying to do is use the due process clause to reform what goes on inside the administrative agencies. And I think in the end, the only way that this will prove to be stable is if you have the same system of rotation and the same system with respect to bias that you have with respect to Article 3 judges, so that what you have to do is to transform the PTO and the PTAB into something which perhaps it wasn't done. Now, why is it that we want to do these kinds of things? Again, it depends upon what you think to be the function of government. I'm just going to end on this particular note. I'm a strong classical liberal. This applies both to substantive issues like the takings clause and the religion clauses and to the procedural stuff. And basically what you're always trying to do in this particular frame is to worry about the risk of faction and how they're going to manifest itself. And there are in this situation two very important risks that you have to worry about in virtually all cases. The first one is any system of indefinite property rights, because the moment it's not clear which way the property right is allocated, all the boo birds will be out and they will be trying to lobby to get it in one direction or another. So under the takings clause, when the Supreme Court says against every system of history and logic that the only thing to which you get protection is exclusive possession, but you don't get any protection with respect to use rights and development rights and so forth, all of those things start to go into political solution. That means you get these terrible intrigues with respect to the zoning laws and the rent control laws and everything else. Does my position mean, in effect, that property rights are set in stone? It does not mean that at all. It means that if you wish to change the property rights, either you show a police power justification having to do with nuisance or some other similar situation, or you show that implicit in-kind compensation has been provided so that you can get social improvements without having to wipe out the person who is there. And if you don't do that, then in effect what you will get is this absolutely Buchanan-like destructive competition to move property rights in your direction. You will never be able to make those rights permanent because what could be done by intrigue today could be undone by intrigue tomorrow. And the second thing that you always have to do with respect to these situations is to worry about the matter of political intrigue. Getting people who are so lined up on one side of the issue or the other that their pre-commitments essentially make it difficult for you to give them for you to have any confidence in their decision. So it is perfectly okay, as far as I'm concerned, to have political officers and administrative officers who prepare the laws to reflect the position of a particular administration. But when it comes to adjudication, the last thing you want to have is a labor board where there are 3 from one side and 2 from the other side, and everybody is pre-committed to a position so that you know exactly what's going to be out. The only thing that's worse than that is something like the Consumer Fraud Protection Bureau, where you have a 1-0 vote, which is fully entrenched, which creates exactly the same problem, which was, of course, the point that Judge Kavanaugh did in his PHH decision, pointing out the general perils. So if you, in fact, impose the kinds of conditions that I'm talking about on administrative tribunals under Article 1, you go a long way to protect against both of these kinds of abuses and to bring some degree of regularity back into the system. So it turns out there's a kind of an arc here. You look at the 2 cases that we're talking about, and both of them on their facts stink to high heaven. And then when you try to figure out why it is, it's not just a matter of individual personalities in these cases. It's a series of administrative rules that allow for appointments and adjudications and rules to be set in ways that make this happen. And the third corollary of all of this has to deal with the kind of the Chevron situation. So if you go back to oil states, part of the mischief in this case was a terrible decision, not worst ever decision, but terrible decision by Judge Breyer, who's horrible on these administrative law matters, who defers essentially to the patent office on matters of claims construction and thereby allows them to adopt the rule which they understand the day they put it into place maximizes the likelihood of patent invalidation by creating such a broad claim. Everybody who drafts one of these claims knows you want to be broad enough so that you protect something that's worth having, but you don't want to be so broad that you bump into somebody else's thing. And when you start to have a, quote, liberal rule of construction, the whole point of it is to create artificial conflicts with other patents so as to lead to their invalidation. And this is just another reason of why it is that Chevron, which was a close case on its merits, but I thought rightly decided independent of Chevron as to saying you could do this particular device, ought never to be extended into those cases where what happens is the notion of ambiguity becomes so broad that the level of administrative discretion becomes so large that in the end what you do is you create the system of indefinite property rights which a strong legal system is designed to deal with. So there's a lot that's going on in this particular case. And to the extent that one sees in the Trump administration an effort to constrain these rules and sees that in Justice Gorsuch and Judge Kavanaugh, I hope is confirmed, on coming tomorrow, I guess it is, what we do is we have a really large fight for the soul of the United States. And as far as I'm concerned, the modern progressive vision of Woodrow Wilson with vast discretion and with separation of powers being a grievous mistake is, in fact, that's the stake in this case. And I have no question that for all of its imperfections, the original vision on this question was far more powerful and far more coherent than the progressive vision which it is now up against and intention. So thank you. I'm happy to take questions if there's time. All right. Even... Well, somebody wants to talk. Bierman! Christ. He's another one of my students, such as it is.
I'm glad that you don't disclaim me, but
I'm tempted.
my favorite course with you was Roman law, I have to tell you.
Well,
but
and by the way, did you like the class?
I loved Roman law.
Well, that's what
it was
we're doing right now. This is all Roman law updated, okay? So you agree with everything I said?
Yeah, exactly. I wanted to ask you about one. You made a comment about why welfare rights are so much different than patent rights, and you lumped patent rights and trademark in the same category. And I think there's a big difference based on traditional common law protections of trade secrets, or I'm not sorry, based on confusion. Actions based on confusion. Whereas I'm not so sure there's a common law tradition of protection of patents. And so I don't, without making any comment on whether the PTAB thing is okay or not, why isn't the isn't it the same thing that you have a government sets a standard for getting a certain benefit from the government, whether it's welfare or a patent, and you go through those, you prove the criteria, and you get it, and it's completely a government created source of wealth. Whereas with a patent, if you don't have patent, you can exploit your technology. You just don't have a legal right to exclude others.
That is correct. But now let's go back to the situation. First of all, if you go back to just the Mattel and Tam, the purported distinction that you made is explicitly rejected in that case, and it was restrictively rejected in the Horn case. The question is substantively, however, why is that the right or the wrong decision? And I think the answer comes, it depends upon the difference is that they're two slightly different theories that are associated. The trademark situation, dealing with confusion, essentially is an effort to deal with the law of misrepresentation, passing off, and so forth. So essentially, if I have a trademark and you're allowed to use it, no longer does it indicate the quality of the goods that I produce. Essentially, it's tarnished by the fact that somebody with inferior stuff can do it. And what the Trademark Act did was essentially to try to beef up the particular protections with a prophylactic rule broader than perhaps is strictly necessary in all cases in order to make this good. The patent situation is very, very different. And what's going on in this particular case is everybody understands that there's a serious limitation associated with the labor theory of value when it starts to apply to various kinds of things like patents and so forth. And the argument in this particular case is, first of all, the labor theory of value is not quite right, so let me first correct it. The view that essentially was done at common law with respect to the acquisition of property rights was not the Lockean view, it was the Roman law view on that issue, which essentially says that occupation is all that is needed to keep everybody else out. This is a huge difference substantively because the occupation rule says do as little as you need to in order to differentiate what you have from everybody else so as to preserve the surplus. If you have to preserve surplus, that is, you get only $1 worth of benefit if you get $1 worth of labor, there's absolutely no gain to getting property because what you get on the one end is something that you've given up on the other end. And so it's the other thing. Now you start looking at the patent situation, and I believe that the same occupation rule is going to be appropriate. And you have a situation where, yes, you can use it, but it turns out that if somebody else can use this thing in its free will and pleasure, the override, the intellectual, basically the ability to borrow it to take somebody else's technology means that you have a complete mess in the marketplace because the fellow who puts in the front end labor in order to create the critical device is going to be at a competitive disadvantage with the fellow who steals it from him because one has to include in his cost of recovery or the cost of running the invention, and the other guy only has to include his marginal cost of imitation. And so what the theory is, in this case, is slightly different from the earlier case. It's that we create a vast, superior situation if what we do is we decide to create exclusive rights. We then ask the question, why is that important? And the answer to that is it stops the freeliding by somebody else, so it induces the invention. But then on the other side is how long do you want to do this? And certainly with respect to inventions, there's always the sense that I may have done it today, but somebody else will do something like it. And there's been an absolute uniform consensus on patents, much more than with copyrights, that these things ought not to be perpetual. So you create a kind of a mixed system. And what you do here is you have a Pareto improvement over a common law system of rights. Now you go back and you start talking about welfare rights. And what you're doing is you're having a transfer payment from the public at large to some particular individual. There's no productive gain from that. Indeed, it's exactly the opposite. There's always going to be a productive loss because what you're doing is you're allowing claimants who did nothing by way of value to claim some value on tax of other individuals. We are living with that in the common society. But at this particular point, the central task is how do we make sure that the system is not completely consumed by the transfer element, and we have to have two ways to deal with that. The first rule is never fund welfare benefits by special taxes on particular activities. And so my favorite example of this is we want to tax laundromats so that we can do in the state of Virginia is give no-fault health insurance to people whose infants suffer serious birth defects. There's nothing wrong with trying to deal with birth defects, but you always do it out of general revenues. Rent control is exactly the same thing. You're asking the landlord to pay an implicit tax to the tenant, and what Justice Scalia said, although he didn't fully act on in the Pinnell case, is you want to put it on general revenues as a dampener. And then the second thing what you have to do when you're giving this stuff out is you have to worry about the problem of abuse. The best article on that was by Jerry Mashal, and what he said is very simple. If the welfare budgets are limits, and the people who are on the system can stay there forever, then it means that people who are really needy can't get to those dollars, given the dollar constraints. And so what we want to do is to find ways to get people off. And of course, Goldberg and Kelly was wrong. That is, this was not a case in which you should have had a predetermination hearing where your social worker will run interference for you. What you do is you allow the termination, and then ex post you could get some kind of challenge, which is what they said was the appropriate regime in Matthews v. Eldridge. But since the problems are fundamentally different between why you create patent protection and why you create welfare systems, it seems to me that the legal regimes that govern them have to be completely different. Or to put it in another form, if you're looking at the Roman law stuff and you're asking whether or not it would have been congenial to the creation of patent rights, the answer is surely yes. If you're going to say whether it would have been congenial to the creation of transfer rights, there is not a single shred of evidence anywhere in the entire body of Roman law literature which starts to talk about transfer payments as being some kind of a property right. Thank you. 6 minutes. Well, I can ask one more question. Somebody?
I could ask a follow-up.
No. I don't want to create a quasi-monopoly. Mr. Merrill.
So Richard, a key part of your due process argument was that non-random assignments judges to panels violates due process.
Yes. You agree?
I think that sounds problematic, but I'm wondering.
Problematic?
I'm wondering, first of all, if there's any historical warrant for that claim. It's not clear to me that, for example, the panels on the federal courts of appeals have always been assigned randomly. In the modern era, I think they are, but I'm not sure historically that was the case. And what do you think about these various statutes that give the Chief Justice of the United States the right to assign judges to specialized courts like the FISA court, which again seems to be a pretty close parallel to what you was talking about with respect to the.
I love you, Tom. First of all, it's very difficult to talk about randomization when you have 3 judges on a circuit and there are only 3 judges, right? So you can't do it. It's also clear, if you go back to the historical times, that we do not have this huge divide because all people were much more in the classical liberal tradition than the progressive tradition. So even if it were non-random, there's not much that you probably could gain out of that. There were probably a few exceptions. With respect to the FISA court, I am on record of having said that it violates procedural due process to concentrate all the powers in the hands of a single Supreme Court judge who can now appoint only Republicans to a particular panel if that turns out to be his inclination. And what I have proposed is, first of all, I can understand why judicial appointments are made in the judicial branch, but if they're going to be 18 people, each justice of the Supreme Court gets to appoint 2. Again, for exactly the same reason. So if your view is, am I willing to blow that system up? Yes, indeed, by good worthy Professor Pierce.
So this is actually, in a sense, a follow-up to Tom's question. As you probably know, the Administrative Procedure Act says that agencies must sign cases to administrative law judges in rotation, unless they have some special reason that they give for it. Would you say that that is also required by due process?
Yes. I mean, look, you guys are pushing me through a door which I regard as being open. And yes, my view is it has to go all the way down. Let's put it to you this way. There's a huge battle as to whether you want to go the administrative route, the Article 1 court, Article 2 judges, if Bamzai is to be believed. Efron says they're one judge is housed in an Article 2 court. You should meet Andrew Efron and talk about this. But the one thing we know is if we've got these divisions and they're here to last, the last thing we want to do is to have a system of procedural due process rules that differ from format to format, because then in effect what you do is you increase the stakes to get it going my way as opposed to your way. And I'm going to do this, for example, to give you another illustration of this, the disastrous literature that passes for understanding of statutory interpretation and so forth is marred by the following incurable mistake. Everybody seems to think that there's some way to get an edge for one guy over another. And the same thing is true with constitutional litigation and with contract litigation. The correct answer is I don't care what system of adjudication you're with. A contract right is construed according to the principles of ordinary meaning, complicated to be sure, which apply to statutes, which apply to Constitution. Now, what do we mean by ordinary meaning? It's kind of complicated. I'm just going to give you the first thing. Is one, if there are textual meanings that are true and textual meanings that are false, you can't say that manufacture is commerce just because you can say it with a straight face. But on the other hand, what you have to do is to be aware that the sensible principles of evasion are always there. So if somebody says, in effect, that you can't take property, it doesn't mean that you allow somebody to essentially say, I'm not going to take your property, but I'm not going to allow you to enter into the property. I'm not going to allow you to have your friends in the property. I'm not going to allow you to sell the property. I'm just going to give you title to the particular property, and you can live happily ever after. Can't do that either. And then you always have to worry about justifications for the deviation from the rule implicit in the words of good reason, which is what you said. If you apply those principles all the way through, then in effect you would get much more uniformity in the way in which laws were interpreted and understood, and much less jockeying. So, for example, if you go into an administrative tribunal to deal with environmental risk, the notion of a nuisance is utterly irrelevant or thought to be incoherent. On the other hand, if you're going into a common law court, it's going to be absolutely decisive. It would be a horrible mistake. It is a horrible mistake to say that what we do is in common law adjudication, we respect the nuisance limitation on private property rights, but in an administrative tribunal we don't, because then you get abominations like the Calvert Cliffs cases where you start moving everything into the federal system and you change the substantive rules by virtue of changing the nature of the decider. So I'm quite adamant on this all the way through. And again, I have not seen anybody who's actually worried about this in a systemic way. Typically what they do is they talk about the virtues of an agency and then give it special rules. My view about it is I want to keep them virtuous, and the last way in which you could do that is to tell them you get the benefit of certain rules because we love you so dearly and so much that we trust everything that you do, notwithstanding the fact that many of you are completely politicized from top to bottom. And if you change the particular rules, then all of a sudden you change who wants to serve on one of these courts and what they're going to do, and the system will work far for the better because of the uniformity. One last question, very quick. Or should I just sit down and run? Yes, Boyden.
Just a little question. Saying the SEC is independent, the president can't do anything. Breyer points out in PCAOB that the SEC was created in between Myers and Humphreys and does not have any four-cause removal restriction. Now, most people don't know that, but I'm just pointing it out.
Okay, that'd be nice. By the way, when was the last time somebody was removed from the SEC?
Well, they all think that there's four-cause removal. So I'm just saying, since I have a small audience here, that there is no four-cause.
Okay, well then, in effect, at this particular point, I will change it. If you got a de facto practice that lasts for 50 years, and in fact, what Justice Robb, the Chief Justice, said, he treated it as though there was some kind of insulation. So I'm responding to him. And look, I'm very uneasy. I think one of the hardest questions in administrative law, in some sense, is do we go along with the validity of independent agencies? And I'll just give one observation about it, which applies to the Article I courts. Humphreys is decided in 1935. The ICC is established in 1887 and has been churning along, right, for 40-odd years, 50 years. Exactly. And it's the same thing with respect to these Article I courts. They were in operation for years, decades, before you come up. And so the real problem about constitutional interpretation from an analytical point of view is the extent to which you take the document as self-contained whole or allow it to be modified by subsequent practice, which is engaged in for a long time. In my classical liberal constitution book, I treat this as a central problem, and I talk about it as constitutional law by prescription, which is the same as adverse possession and so forth. And the thing to understand about prescription, unlike custom, is prescription is basically overriding an existing right. And custom is trying to define what that right is without overriding anything. And we do both, and in various degrees. And I think, in effect, you cannot run constitutional law without prescriptive rights. Let me give you the simplest illustration. Do we have diversity jurisdictions over corporations? Well, the answer is obviously no, because these people are not citizens. They're artificial entities of the state. On the other hand, by 1855, every corporation was a citizen of the state where it was incorporated and of the state where it did practice, even if it turns out that many of its shareholders were aliens. Well, do you really want to go back on that decision? Nobody does. Well, it's pure prescriptive constitution. So the dangers, Mr. Rappaport, of originalism is we don't want to pick the cases where the deviations are large and indefensible and assume that all other things that never get controversies about them, like the citizenship procedures, are in fact originalist decisions. It's a very complicated amalgamation. Article I courts are that way, and the reason why Aditya lost in his case, he wrote a wonderful brief, by the way, is that Justice Kagan said, we've been doing it this way for so long, I don't want to blow up the universe because I don't know what's going to happen in its place, to which there are answers, well, we can fix it in one way or another, and this is the world of the second best, and on those particular situations, whenever you deviate from an optimum, there is never a clear rule to tell you what you do. If you go back to the game theoretical literature, and Lucian Raphael, way back when in the early 50s, said, if the ideal rule is x equals y in all cases, and you get off that diagonal, you immediately go back to it? You say parallel to the diagonal? You try to get back to it slowly? He says, I don't know what the answer is. And that's what judges have to do when there's an early decision which embodies a mistake. And the basic rule of thumb that I have is if the mistake is consistent with classical liberal values, keep it. If it's not, don't. That explains why we keep Article I courts and go after Plessy and Ferguson and Korematsu. Thank you. It is okay?